Welcome to the Real News Extra. My name is Fred, and joining me today is Jennifer Felten, the principal and founder of RELAW APC. So Jennifer, what triggered this month's featured case?
This month's featured case involved a home that was being remodeled, and multiple contractors were hired, subcontractors, to try and manage this remodel.
Okay.
One of the concerns was the soil and the foundations relative to this property. A vendor, an engineering firm, was hired to analyze the soil and determine whether this addition could be built or not. They said it was safe to build, and they built, and it fell off the hill. So Slight problem, right? I mean, it's a pretty serious damage to the existing structure, and the newly built pieces were problematic as well.
Yes.
In this case, the contractor, the engineering firm, was not in direct contract with the homeowner, which is not uncommon in building because subcontractors and kind of how all that works. And so the question was whether the homeowner could sue the contractor who they did not have a direct contract with. And so that's what the case was about.
Got it. How does the legal concept of privity come into play in cases like this?
Well, that's the issue, right? So just because you don't have a breach of contract cause of action, right, because there's no direct contract, there's this concept of privity where if you're doing something where you know who the intended beneficiaries are, right? You were hired by a contractor to do a soils report. If you know it's for the homeowner and the homeowner's damaged, you can't pretend like you didn't know that What you were doing benefits that homeowner. So that homeowner was in privity under California law, or that was the issue. The appellate court found that they were in privity, and so allowed the case to go back to trial for the consumer to make their arguments against the contractor.
Got it. What are some of the implications for both homeowners and professionals when it comes to cases like this?
Well, first, you should get a contract.
Yes, always.
Right?
Get it in writing.
Even when you're working with a contractor who's hiring subs, the homeowner or the person contracting, right? The person who hired the contractor should be a party to all the subcontracts as well, right? So then we wouldn't even be having this discussion because there would be a contractual relationship. Even if they're not paying the consideration directly because they're paying the contractor, if we had a contract, none of this would have happened. Secondly, you can't avoid your liability by not having someone sign a contract. For the most part, people are not general agents and don't have a duty to the public.
Right.
But when you're doing something, whether you're an attorney or a contractor or a grocery store worker, your actions, you know who they're affecting, and if those persons are damaged, you can have liability. And so understanding that not having a contract is not going to get you out of all liability is something they need to be prepared for.
It's not a get out of jail free card.
It is not a get out of jail free card.
Yep. Well, thank you for watching this episode of the Real News Extra. If you're enjoying this content, please click on like or subscribe and ring that little bell for notifications. My name is Fred, and I look forward to seeing you on the next episode.